Welcome back. This week, we're reading a series of articles about recent changes in the Department of Education's policies regarding sexual assault in educational settings, in particular on college campuses. This is a really complex issue, and this video is designed to provide you with some historical background on what is going on and what the Department of Education is responding to, as well as to help you clarify kind of what the Department of Education's new position is and how it differs from prior positions. So, first and foremost, is a little bit of clarity surrounding what occurs if a student is harassed or assaulted in the context of an educational setting. Um, if a college student is harassed or assaulted, there's two different responding mechanisms. The first is law enforcement. So the student may choose to file a complaint with their local police. Um, if the police determines that the student has a case, then law enforcement will begin the process of gathering evidence, arresting the person accused, and then essentially, helping the prosecutor to create a case to be tried in a court of law. But there's also the university piece. The university will need to determine if the accused is a danger to the campus or to the person who's doing the accusing. And the university will also need to provide support services to the student who has reported a sexual assault or harassment. So that's the background to help provide a sense of context for this issue. So here's the history. In 1994, universities were required by law to adjudicate decisions about sexual assaults that occurred on their campuses. And they were also required to sort of provide some consequences resulting from that adjudication. So, adjudication means to make, in this case, a determination about whether or not a sexual assault took place. Um, and this adjudication, as of 1994, needed to take place regardless of whether a student decided to file a complaint with their local police. So, since 1994, students have been complaining that A, sexual assault and harassment were really rampant on college campuses, and B, that college administrators weren't doing enough to address this issue. And these complaints came to a boiling point during the Obama administration through a series of well-publicized cases, as well as some students speaking before Congress. So basically, in 2011, the Obama administration's Department of Education put forward a set of guidelines to help college campuses determine how to handle sexual assault. These guidelines were not binding. They weren't codified legal rules, but were rather a set of recommendations that were meant to beef up the university's response to campus assaults and harassment. So here were some of the guidelines. One, the Obama administration required schools to investigate any complaints about assault or harassment, whether those incidences took place on campus or off campus. So, for example, if a student was harassed or assaulted at a fraternity lodge that was off campus, the university still had to respond to a complaint that was filed about that. In addition, the Obama administration discouraged mediation between the accuser and the accused. That is a situation where the accuser and the accused would sit down with one another and would talk. Their recommendation was that any kind of a mediation would re-traumatize the person who had been either assaulted or harassed. And finally, the Obama administration advised universities to use what was called, quote, a preponderance of evidence, end quote, standard to determine cases of sexual assault. In other words, they advised that the university should determine an accused guilt by asking if it was more likely than not that an assault had taken place. And under the old system, universities used a much higher standard of evidence. So in 2017, Betsy DeVos rescinded these guidelines, and she instead put forward a proposed set of rules. After a period of commentary, those rules were instituted basically in 2018. Now, as a reminder, Betsy DeVos is the Secretary of Education under President Trump. And unlike the prior guidelines from the Obama administration, DeVos has instituted a set of binding rules. And here's the rules. One is DeVos's rule is that schools are only required to investigate complaints about incidences that take place on their campuses or in their own programs. So, for instance, if a student is assaulted off campus, then the university really isn't required to respond, though they may choose to do so should they want to. Two, schools are only required to respond to complaints that are filed on behalf of students by school officials. And the definition of a school official is, quote, an official who has the authority to institute correcting measures, end quote. In other words, it means a school administrator. So if a complaint is filed by an RA, let's say a residential advisor, that's not going to count as an official complaint. Um, DeVos allows for mediation, including having the accused and the accuser cross-examine each other. DeVos allows schools also to choose their own evidentiary standards. So if schools would like, they can use the Obama administration's recommendation of preponderance of evidence, or they can adopt the pre-Obama recommendation of, quote, clear and convincing evidence, which is a higher standard of evidence to determine guilt. And finally, the DeVos administration explicitly outlines that a school's treatment of the accused can constitute grounds for a sex discrimination case, just as the school's treatment of the accuser can constitute grounds for sexual discrimination. So earlier, if a school did not respond appropriately or robustly to a student who had filed a claim of sexual harassment, then that student could sue the school for what's called a Title IX violation. That is a violation basically stating that the school is discriminating against the student on the basis of sex or gender. But under DeVos's ruling, this is still kept a possibility, but in addition, she's also providing more rights to the accused. So if a student who has been accused of harassment or assault feels that they've been treated unfairly by the school, then that student can now sue the school for sexual discrimination. Now, these are a set of rules, right, that have been instituted. In truth, many universities overhauled the way that they handle sexual assault and harassment cases after 2011. And while many universities will probably end up keeping their current methods intact, critics are concerned that many universities will end up changing their guidelines or rolling back their guidelines in conformity with DeVos's new rule. And that new rule allows for more latitude in terms of what universities are required to do, and also provides more protections for the accused. All right, so that's the background to help you with your reading. Please let me know if you have any questions. If not, I will look forward to seeing you on the discussion board.